The next case is People versus Corley. This is also an argument on the application. You each have 15 minutes. You can reserve time if you succeed.
Thank you very much. Good morning, Craig Daly on behalf of Diallo Corley, and I would like to reserve 2 minutes for rebuttal. So when it comes to the factual scenarios for newly discovered evidence, they tend to fall on a continuum, and at the one extreme, we have the recanting witness, which often is a prosecution witness, often a co-defendant who has been given a deal by the prosecution, who testifies at trial, and then after spending a long time in prison, signs an affidavit saying, whatever I said at trial was not true. The police or the prosecutor promised me something or threatened me, and that's why I lied at trial. In those cases, rarely, and for good reason, end in a new trial. And as we move along the continuum to the middle, we have impeachment evidence, which this court in Grissom said could result in a new trial, especially if it falls in the category of exculpatory evidence. We move further on the continuum, and we fall into the category of this case, which is an independent, neutral eyewitness who has seen the incident and testifies under oath that it didn't happen in the way that the only eyewitness for the prosecution has testified to, and provide evidence of the actual innocence of the defendant. And that's what we have with Mr. Johnson. Mr. Johnson gave detailed and compelling testimony about what happened in this case. So this court, in its order, asked us to file supplemental briefings with regards to the trial court's conclusion that newly discovered evidence would not make a different result probable on retrial. And the only thing that we're addressing here is the fourth requirement for newly discovered evidence. The parties below, the lower courts, all agree that we have met the first three requirements. The court's recent decision in July of 2018 in the Johnson case is helpful in determining how you should address this fourth requirement. The test is an objective test. What a reasonable juror could credit the testimony of Mr. Johnson. It's not the trial judge's particular subjective opinion of the witness, but it's an objective test, which is very different than what the prosecution is suggesting that you adopt, which is an actual probability. That test about reasonable probability is probably the lowest standard that the defense has to meet in a criminal case. It's not a preponderance of the evidence. And notwithstanding that, the trial court should be given deference in terms of its credibility determination. Johnson teaches us that the appellate courts are to look and scrutinize what it is that the trial judge actually determined, not to turn a blind eye to what the trial judge said. The trial judges, when confronted with newly discovered evidence of this sort, have to look at the entire record. They have to look at the newly discovered evidence, the evidence produced by the prosecution at trial, and also look at what would in fact be admitted at a new trial.
Counsel, normally we defer to a trial court to do all the things you just, I don't disagree with
Yes.
anything you've said.
Right.
We defer to the trial court because the trial court's just in a better position than we are to assess credibility of witnesses and think through exactly those questions you just identified. What do we do in a case like this where the prosecution has conceded that the trial judge's assessments were all, I don't know how I would characterize. I'll let brother counsel decide how to handle that. But what kind of deferences do in a case like this? Or do we have to start from scratch and do our best to assess credibility on a cold record? What do we do in a case like this in terms of our appellate review standard?
Well, I think the starting point is by law you have to give the trial judge deference, but that doesn't mean that you turn a blind eye to it, of course. So I think the process is you look at the trial judge's factual determinations for clear error. You look to see whether or not the trial judge applied the correct legal standard. And you look to see whether or not the judge applied the facts properly to the law. I think that's what you're going to look at in its entirety. You have to look at the entire picture. And then in reviewing what the trial court did, you look at what determination did the trial judge make in terms of credibility. So that's the first step. I think that's what Johnson tells us. So in this case, what Judge Callahan did is that instead of addressing the content or the substance of what Mr. Johnson said, because he never said, I reject his version. He never says that. The only credibility determination that he makes on the record. So to answer your question, we're looking to the record. We're looking to see what the judge said in terms of credibility. And here, the judge only addresses Mr. Johnson's prior conviction. Okay? So it's the armed robbery conviction in 1994, for which he was released in 2011. And the trial judge says that that will be used in a new trial for impeachment. So you have to determine whether or not, in fact, that is a correct analysis. And the prosecution concedes that Judge Callahan didn't engage in the proper analysis under 609, whether or not, in fact, that would be admissible. Judge Callahan is retired. He's not going to make that decision. Somebody else is. Let's assume, just for the purposes of argument, that the new judge says that he can be impeached with his prior conviction, that it's more probative on the question of credibility than prejudicial. What effect would that have? Well, the jury is going to be instructed that they can accept that for whatever weight they want to give it. They don't have to totally discredit Mr. Johnson based on that one factor. And just in our experience in dealing with cases, we know that the prosecution often uses witnesses with extensive criminal records, and they still get convictions. They don't entirely throw out the witness's testimony because they have a conviction. So when we're looking at the credibility determination for the court at an appellate level, we're looking to see what it is that the trial judge used for credibility. The trial judge never said that Mr. Johnson's testimony was not believable, was not inherently incredible, but only could be impeached. So that's the first factor. And the other thing in terms of credibility that the trial judge did not consider, which is the government's case or the prosecution's case in terms of Mr. Ray. Mr. Ray was the victim. He also had a conviction. So that would be balanced out. And not only did Mr. Ray have a conviction for a theft offense, which the jury would have to balance and consider, he lied about it during trial. He said that he was convicted of a misdemeanor when, in fact, he was convicted of a felony. And the other things that the court didn't address that this court can look at in terms of the credibility determination is that Mr. Johnson gave a sworn statement to an investigator, and that's in the appendix. You can see that. After we filed our motion for a new trial with the affidavit, the Wayne County Prosecutor's Office sent out their own investigator to speak with Mr. Johnson. He didn't have to speak to them, but he met with the investigator, sat down, gave an hour-and-a-half interview and a written statement. The affidavit he gave to the investigator, the affidavit that he gave, the statement that he gave in the taped interview to the prosecutor, and his sworn testimony are all consistent. All that go to his credibility that the trial judge never addressed. And we have a witness, Mr. Johnson, who is completely neutral. He doesn't know either of the parties. He doesn't know Mr. Ray. He doesn't know Mr. Corley. He has no motive to lie at all. And in his recitation of what happened, why he was in this area at 114 Avalon in Highland Park, he tells the court, in open court with other people present, that the reason why he was there because of a previous homosexual rendezvous that he had set up. Now, how many people are willing to come to court and expose themselves to that potential ridicule to explain why he's there? That also lends credibility to what he's saying. I'm sorry.
You're doing a great job of describing what was presented below, but with this trial judge, we just had a case where we're talking about policies of trial courts. I have a little concern with this judge who's now retired that perhaps he had a policy. I mean, it seemed to me I'd see cases over and over when it came to credibility determinations, particularly newly discovered evidence or post-judgment motions. If a witness had a criminal record, they were not credible. If the witness had no criminal record, they were credible. Not on the basis of their demeanor, how they testified, what they were able to observe, the typical things that you would expect a trial judge to do in assessing credibility. It was simply this threshold test, conviction, no conviction, credibility, no credibility. Given that, would it be a suitable remedy to send it back for another evidentiary hearing on the question of whether a new trial should be granted on the basis of newly discovered evidence, as opposed to people just looking at transcripts and trying to size up what should be done?
Justice Sauer, I'm not sure that you're suggesting that we have an evidentiary hearing with Judge Callahan testifies about his policies, but is that what you're suggesting?
No. Just send it back for an evidentiary hearing, a new hearing on the basis of whether a new trial should be granted on the newly discovered evidence.
We've had that hearing, haven't we? We've already had the testimony.
And you had a trial judge who made a determination.
Yes.
That referenced, I can't remember the witness's names, but you went through it a few minutes ago about the conviction and whether that conviction essentially, in his view, would render that witness lacking in credibility and essentially, I think, made his determination on the basis of that alone.
I don't see the purpose in that. I think you can rule based on the record before us. I don't think the record is cold in the sense that you've said. And just to comment on what you referred to in terms of Judge Callahan, the Johnson case that was decided in July was a Callahan case, right? In the appendix, I also attached the Hunter case, which is also a Callahan case, where the court said his determination with regards to credibility of the defense lawyer wasn't supported by the record and reversed. I'm not saying that every time Judge Callahan was involved in these types of cases, he did A, B, C, D. I think those are examples, that those are more examples of his inability to really analyze the total record. And that's part of the problem in this case. He doesn't look at the entire case. He's not looking at Johnson's substantive testimony. He's not even looking at the prosecution's case, because the prosecution's in this case clearly was not overwhelming. I mean, we have a single witness, right? We got the eyewitness, Mr. Ray, no corroboration for what he says, no circumstantial evidence that supports him, no scientific evidence that links him to the crime, Mr. Corley. no firearms, no identification to the vehicle that he was supposedly in. Mr. Ray doesn't identify Mr. Corley for 3 months after he was shot. 3 months. And we know that Mr. Ray lied under oath, right, at the preliminary exam and admitted that. He lied to his therapist, saying that he was shot during a robbery rather than a drive-by shooting, because he thought that if he told his therapist that, he'd get better medical treatment. And I think probably the most important thing in my mind is there's absolutely no motive for Diallo Corley to want to shoot Mr. Ray. The best thing that they could come up with was that Mr. Ray was crowned, whatever they call that at homecoming, king of the court.
Yeah, 7
king
years
of the court.
earlier.
7 years earlier.
Yeah. Okay. I understand.
Okay.
Thank you, counsel.
Okay. Thank you very much.
And good morning once again. John Voitala, representing the people of the state of Michigan. In Johnson, this court addressed the fourth prong of the Kress standard, and in doing so, bifurcated the analysis. The first analysis being whether the new evidence is credible. And in doing so, the court set out a burden which, in practice, is fairly, the defendant can meet with a minimal amount of effort. But the court was not as clear as to what the burden would be on the second part, which is the impact of that evidence on the result of the trial. By correlation, this should be a very high burden. This should be one that's very, very difficult for a defendant to meet. The reason why is because, as Kress said, what the defendant needs to prove is that the new evidence makes a different result probable on retrial. Not could, but makes a result probable on retrial. To warrant the granting of a new trial, the defendant's burden is to establish that it is reasonable that a different result, one that is favorable to him, is probable if the new evidence is considered. As Professor Lefebvre has noted, a hung jury is not a favorable result. The defendant's burden is to show that the jury, all 12 of them, not one, but 12, would have come to a different conclusion based on this new evidence. And it goes along with the decisions of this particular court that said that motions for new trial based on newly discovered evidence are disfavored, viewed with great caution, unusual, and in those instances where the trial court has denied a new trial, as Justice Markman stated, reversal of those decisions will be few and far between. So it's a high burden the defendant needs to prove on the second part, the impact. So even if you look at Judge Callahan's analysis, and I'm saying that he didn't apply the Johnson standard, because obviously Johnson came afterwards, after the decision in this particular case. So even if he didn't apply the correct analysis as far as the credibility, his determination that the impact would not have convinced 12 jurors to change their verdict was not outside the range of principled decisions. It was not an abuse of discretion. Any questions?
I have the same one I asked Brother Counsel. What deferences do we owe this particular trial judge, given the concessions you've made about his work? Well,
I think because he did apply the wrong standard as far as the first stage, the credibility stage. I don't think the court can give it as much deference as would be expected normally. But on the second part, I think Judge Callahan is due his deference on this particular case, because he was the trial judge. He heard the testimony. He was present when all the testimony occurred, saw it live, was able to determine look at the witnesses, was able to talk to the jurors afterwards, et cetera, and was able to have this history to make the determination of, now that I've seen this other evidence, both this newly discovered witness and the witness who was supposedly in the backyard and showed up later on, now that I know this evidence and compare it to what was presented at trial as a whole, do I find that a jury would have reached a different verdict? I think you need to give that due deference.
I mean, counsel, I guess, it's interesting. I do everything from memory, so I have to internalize all these cases. So I just want to quickly kind of walk through a little bit with you in terms of the argument that you're making, and just to kind of understand exactly what your position is in terms of the impact on the jury. And ultimately, I mean, in this situation, as we've learned, you don't have any physical evidence of any kind. And you have a situation where a witness comes forward and basically gives a completely different description of the alleged shooter in this situation. I mean, a completely different description. He gives a very good description of the neighborhood. He gives a description of the house he was going to. He doesn't seem to have any real bias in this case, doesn't know any of the parties that are involved in it. And I guess I just want you to kind of explain to this court, looking at the standard that we've been discussing, how that doesn't possibly have a probable effect on how a jury could see a case where identification is the only correlative issue that we're looking at.
If this was a full grant and I had 30 minutes to tell you all the reasons why this evidence is incredible, the new evidence is incredible.
Well, we understand that there was a conviction of the witness that came forward, but going to what Brother Counsel was arguing, I'm trying to understand from you how his story wouldn't have a potential effect on a jury.
Well, the question is the standard of review for this court is whether Judge Callahan abuses discretion, and that is,
right,
was his decision within the range? So you may be able to sit here and say, okay, well, I would have believed this new evidence, but is it outside of the realm for Judge Callahan to say, no, the jury would not have bought this? Now, there's a lot of things about the case. As I said, if you want, I can go through all the reasons why I don't think his testimony is credible.
Right. But keep to the highlights of it. And I guess I'm just still trying to get a sense from you how you would answer that question, though. I mean, in terms of the range, I'm just not seeing. I'm trying to understand in terms of the standard that we're applying.
Right.
As it pertains. I mean, look, we're not here to decide innocence or guilt. We're trying to apply and approach the standard. And I guess what I'm trying to understand is, as you apply the standard, how it doesn't rise to the fact that, a different jury could reach a different result with the standard that we're applying.
Okay. So
based on an eyewitness that, as we talked about before, that is impartial, that, described a totally different person, and that's kind of what I'm trying to get to. When the whole case comes down to eyewitness identification.
Okay. Well, as I said, what I believe the standard for this court is whether 12 jurors would reach a different, not whether it's possible or probable, or I'm not probable. Sorry. If it's possible or it could have happened that the jury could have looked at this and come to a conclusion differently. It's would 12 jurors. Would they have reached a different conclusion? Now, the evidence in this particular case, I think, if I want, again, I could go into the whole reasons why I don't think that this is credible evidence. Because, first of all, you have two different, you could look at two different versions of this particular evidence. If you look at the rules of evidence, there's a credence given, a deference to, the closer that a particular story is given to the time of the instance. Look at the hearsay rules.
Okay.
They're given a little more credibility. Now you have the victim here who, were to believe that he totally made up every single detail of him getting shot when he reported this to the police immediately afterwards. That, no, it wasn't a car that drove by and shot me. It was some guy who jumped out between two houses.
But then we have that second witness, Day, that says that he was in no condition to be able to even communicate or speak. I guess we're just going to go in a circle, I guess.
Right.
So.
And my point, Your Honor, is that could this court look at this and say, well, it could have happened, it could have been reached a different verdict. that's not the standard that this court should reach. The court, first of all, has to find that the jury would have reached a different verdict. Second of all, this court needs to find that the fact that Judge Callahan found that a jury would not have found a different verdict based upon this evidence, that is outside the range of principal outcomes.
Okay. Thank you, counsel.
Yeah.
I see no further questions. Thank you, counsel.
Thank you.
The case will be submitted.